We don't want to be used as a promotional material for these companies in saying that we are working with Indigenous peoples, we're giving them this kind of support. That's not the kind of partnership that we want.
Hi there, and welcome to Voices from the Institute for Human Rights in Business. I am Deborah Sager, and in this podcast, you will hear from people working to make respect for human rights part of everyday business. Coming up, you're going to hear about how companies can respect the rights of Indigenous people during renewable energy projects through concepts like FPIC, free, prior, and informed consent. You've just heard from Robie who's from the Philippines. You'll also hear from Prabin from Nepal. They're both specialists in this area. Global concerns about climate change and the pollution caused by fossil fuels means there's huge demand for renewable energy. But what's the human cost? Let's find out more from my colleague Francis House. Francis, can you tell us more about why you wanted to cover this issue?
Yes, we're at the early stages, I think, of the green rush in the transition to net zero, which means governments are granting licenses to energy developers in many countries around the world, including on Indigenous land, but without government or companies necessarily undertaking proper human rights due diligence, and without following human rights due diligence and following proper processes like FPIC or abiding by ILO Convention 169. And for those not familiar with that, that's the International Labour Organization's Indigenous and Tribal Peoples Convention. It's international law which secures the right for Indigenous peoples to decide their own priorities for the process of development. It secures the right for them to exercise control to the extent possible over their own economic, social, and cultural development. So very important. Free, prior, informed consent and ILO 169 are very important international frameworks to keep in mind as we discuss these issues. So one of the things I really wanted to dig into with Robie and Prabin in this podcast is this issue of, in the green rush that we're seeing, the growth of renewables, are there opportunities for shared prosperity for Indigenous communities to be entering into partnerships and agreements with companies as we're seeing this massive increase in renewable projects?
Why did you want to speak to Robie and Prabin in particular about this?
Robie is the coordinator of Indigenous Peoples' major group for sustainable development and the coordinator of the Right Energy Partnership with Indigenous peoples. So she's based in the Philippines and has done an enormous amount of work on renewable energy and impact on Indigenous communities in the Philippines, but her experience is global and her insights and lessons learned are important for companies and regulators to be listening to. And equally, Prabin, based in Nepal, has enormous experience that needs to be shared. He's the convener of the Asia Indigenous Peoples Network on extractive industries and energy. And as well as that, he's the founder and coordinator of the Community Empowerment and Social Justice Network. So through the outreach of his network, similar to the work that Robie is doing, they are both of them working directly with Indigenous leaders on the ground in many different countries, and therefore they are accruing an enormous and an important body of evidence as to the impact of renewable energy projects on Indigenous communities, as we are at the early stages of this exponential growth in the industry. So their perspectives are tremendously important to listen to.
Thank you so much, Francis. You'll hear from Prabin soon, but first, let's discover some of the human rights challenges Robie has observed for Indigenous communities.
One of the dilemmas or challenges is the increasing mining of critical minerals. These are the minerals that are needed to be able to produce all these clean technologies. And we've seen in the recent years with this transition to renewable energy that there's been increasing mining of lithium, nickel, and other critical minerals in the indigenous territories. There's also the increasing mining of silica, one of the main minerals that's used for solar panels. This mining are happening without the free, prior, and informed consent of indigenous peoples. A lot of indigenous communities are opposing this because of the destruction that it could cause, not only to the environment, but also to their livelihood. From the production of these clean technologies in the actual deployment of these, again, it's causing displacement to a number of indigenous communities, like some projects in India where indigenous peoples are being displaced for solar farm, or the wind project in Norway that's going to impact the livelihood of the Sami indigenous peoples. Now, the thing here is if there is no respect and recognition on the rights of indigenous peoples as enshrined in the UN Declaration on Human Rights, particularly the right to land and resources and right to free, prior, and informed consent, this would really cause a lot of adverse impacts to indigenous peoples. At the very onset, it's very important that there's this recognition and respect of rights, and that communities are aware and are informed of what these projects are and how it would impact their communities.
You make such an important point about the fact that when we're looking at just transition, the temptation often is just to look at the wind farm, the solar farm, the hydroelectric dam, without looking at that supply chain of the transition minerals and metals. And the exponential growth in renewable energy is going to see an increase in mining of all of those minerals and metals that you've touched on, and many more, with huge impacts on communities. You mentioned free, prior, informed consent. Prabin, could you just give a very quick overview for those listeners who may not be aware of FPIC, as we refer to free, prior, informed consent, what the headlines of that are, why it's so important in these discussions?
Yeah, so free, prior, informed consent, FPIC, is basically the principle or the right of indigenous peoples to self-determination over their lands, territories, and resources. Basically, it means that no decision can be made regarding the lands and resources of indigenous peoples that they have traditionally owned, occupied, used, or otherwise acquired without obtaining their consent, which is obtained through a free process without any pressure or threats. Consent needs to be obtained prior to deciding on a project that impacts their lands and territories or their lives, and to an informed process. So that means that the communities have to be provided all the information that they need to make a decision through their own decision-making process. As a matter of principle, grants the communities the right to say yes to the project if they think that this is in line with their self-determined priorities or for development. They also have the right to say no. They do not agree to that project to be implemented in their lands and territories. Thirdly, they also have the right to say conditional agreement. We are okay with the project if these conditions are met. And these conditions can be, change in the project design, benefit sharing agreements. These conditions can be how they participate in the project cycle altogether. And finally, I think FPIC should not be understood as a mere one-time process whereby it's a tick box exercise that a company or a project has consulted with the communities and provided them some information, which is often the case that we see. But FPIC as a standard practice should be a process throughout the project cycle, whereby it is obtained at the beginning of the project and throughout the project whenever there is major changes in the project, any change that will be made throughout the project cycle. FPIC is basically the tool that indigenous communities have been asserting to safeguard their rights in the context of these projects, and non-respect for FPIC has been the biggest challenge in most of these transition mineral mining projects.
And non-respect for FPIC, I think also we're seeing emerging more and more in terms of certainly wind farms in Colombia, in La Guajira. We see protests in Norway. Robbie, you mentioned the case that the Sami reindeer herders brought to the Supreme Court in Norway because their rights had not been adequately respected as mandated under Norwegian law, and their case won, the Fosen wind farm case. So I wonder, Robbie, if you could just reflect on lessons that you have learned from the Right Energy Partnership in India, where you are looking to find models of where FPIC is being done appropriately and meaningful dialogue is part of the approach. Lessons from there that can be applied where potentially things are going wrong and FPIC is not being respected, as Prabin has described.
We're not particularly working in India right now, but in terms of lessons learned on the implementation of FPIC, what we see here is that for countries to have legal recognition on the rights of indigenous peoples or who have ratified ILO Convention 169 and have somewhat in place in their legal system a recognition of meaningful consultation with indigenous peoples. A lot of these are just more in paper, and implementation has been very, very problematic. Most often, they see this as a very tedious and expensive process that they have to undertake. As Prabin mentioned a while ago, it's being looked at just as a checklist, just as a procedure that they need to comply with to be able to implement the project, instead of looking at it as a process of engagement with indigenous communities to be able to know their needs and priorities, and for example, on the assessment of risks and impacts, how it would impact not only their livelihood but also their traditional practices. I think the other lesson on FPIC is that it's too focused on the patriarchal decision-making system of many indigenous communities, and what we are pushing for in the free, prior, and informed consent is a collective decision-making that involves all members of the community, where all voices are heard: women, youth, elders, persons with disabilities, because they also have distinct perspectives, needs, and priorities that needs to be heard in the process of obtaining the free, prior, and informed consent of communities. And lastly, another lesson learned, it does not end with a memorandum of agreement with communities, because most of the time, this is the proof that companies and governments show that they have conducted FPIC. And after that, there's even no implementation of what's been agreed on in the memorandum of agreement. Again, the free, prior, and informed consent is a process of continuous engagement with communities, continuous negotiation with communities to ensure that the project is responding to their identified self-determined needs and priorities.
One of the potential opportunities then, if it were possible to get alignment between responsible companies and governments who are genuinely upholding their commitment to legal recognition of Indigenous rights, ILO Convention 169, if those two sides of the equation were in place, do you see there is genuinely an opportunity for shared prosperity, for economic empowerment for impacted communities? Are you seeing mechanisms in Nepal, for example, where there is meaningful consultation, there is continuous engagement, and there are mechanisms for revenue sharing, for benefit sharing between a renewable energy project and a local community?
Based on my work in Nepal, working with the communities, indigenous and other communities affected by hydropower and other infrastructure development projects being aggressively pushed by the government as well as other development actors in the country, I wouldn't say, Nepal, though it is the only country in Asia that has ratified ILO Convention 169, and it also voted in favor of adopting the UN Declaration on the Rights of Indigenous Peoples at the UN General Assembly in 2007. Nepal still, despite those international obligations, international human rights obligations, does not present a good practice for the respect of FPIC. The communities have continuously struggled in Nepal and beyond to get recognition of their traditional lands and resources, because often these lands and resources are collective, and the laws only provide individual land titles in many countries that we have been working with indigenous communities in. There are only few countries in Asia, Philippines being the one, Cambodia being other, that provide for collective land titles for indigenous peoples. There are similar initiatives in other countries too, but not fully in line with the UN Declaration on the Rights of Indigenous Peoples and ILO Convention 169. The communities, indigenous communities affected by hydropower projects in Nepal have been leveraging international financiers of the hydropower projects to ensure that their right to free, prior, and informed consent is respected. So there has been some efforts made by the projects, particularly the financiers of the projects. For example, in the case of the Upper Trisuli 1 project, which was co-financed by International Finance Corporation and other multilateral development banks, including AIIB, Asian Infrastructure Investment Bank, and ADB. So there have been some efforts made to obtain FPIC in those projects, but still we have a long way to go. Nepal, the government of Nepal does not recognize collective rights of Indigenous peoples to their lands and resources, let alone their right to free, prior, and informed consent in the domestic legal framework. So that basically leaves the first step unaddressed, no? And that is the basic reason why often communities have to get up in arms against these projects, which they believe might result in national good, but they still have to oppose these projects because these particularly large-scale projects often lead to disproportionate impacts on these communities than the benefits that these projects bring to them. No, having said that, there is some benefit sharing regime that has been put in place in Nepal through national laws and policies, which have led to some kind of positive impacts on the impacted communities. So these benefit sharing regime consists of 5 particular mechanisms. Firstly is the royalty share mechanisms, whereby a project has to distribute royalties that it generates at different levels of government, 50% going to the federal government and 25% each going to the provincial and local governments. All of these royalties are expected to prioritize the good of the affected communities. Secondly, there's also the regime for issuing shares to the affected communities. It comes from a regulation whereby a publicly listed hydropower company can issue up to 30% of its shares to the public, 15% of which has to go to the affected communities at premium or minimum value. So that has also led to some communities getting more ownership or feeling more ownership of these projects. Thirdly, CSR, or like corporate social responsibility activities of the companies that they do out of their own good without any legal obligations on them. These activities give the companies the social license to operate. These include trainings and job opportunities for the affected communities. Then there's also the aspect of social community development programs that these projects implement. Often these include irrigation schemes, schools, hospitals that are being granted. And lastly, that we have very limitedly seen is to provide the credits, or paying for the environmental credits of the damage that is done on the environment by these hydropower projects. So there's this kind of benefit sharing scheme that is already in place and being practiced by a number of companies. However, what we see in our research and research done by other esteemed organizations is also that these benefit sharing schemes is implemented to a larger scale by small scale projects than large scale projects. Large scale projects are the ones that the government is aggressively or vehemently pushing in Nepal right now, including mega dams that are more than 1,000 megawatts, including cascade of dams that are damming a river at different areas. And often for those projects, the communities, affected indigenous communities and other communities, including environmental activists, have been saying no at the outset, that these projects will not do the good to the communities or the environment than the economic benefits that it will bring through the generation of electricity.
That point about where you are seeing benefit sharing is happening more where you've got community scale energy projects than the large, either state-owned or the mega energy projects, I think is true in many different places. Robie, I just wanted to come back to you really to see if you have got a clear call to action to energy developers, to companies, if they are genuinely to secure their social license to operate, respecting FPIC, but in a way that also delivers benefits, delivers shared prosperity for affected communities. What would your call to action to those energy companies be?
I think what's important here is the recognition and respect of the right to self-determination of indigenous peoples. We've seen, for example, in renewable energy that indigenous peoples can manage their own resources and be able to generate investments and income supporting their community. We have this Navajo Power in the US that's been installing solar panels in many indigenous communities, but also servicing other non-indigenous households. We also have an example of the geothermal power plant managed by indigenous peoples, the Maori in New Zealand. And there's a number of examples in Canada where they are promoting energy sovereignty for indigenous peoples, wherein they are the ones managing their own resources and using it to support their communities. It's important to not look at it as a very top-down approach because Indigenous peoples can contribute to sustainable development and to this transition to renewable energy. If it's in line to our self-determined priorities and we are given the independence to be able to implement things on our own, that would likely succeed. If we're going to rely on partnerships based on benefit sharing, in many cases, it has not succeeded in many Indigenous communities because most often the benefits that are being provided to affected communities are employment, where no upskilling is being done for them to be able to go up from rank and file up to the management. And most often, they are employed in the first few months of the project implementation, and then they are replaced by outsiders. The other thing that companies have been dangling to communities is the scholarship, which we know is the priority of many Indigenous peoples, providing education. But this is not the kind of benefit sharing that we're looking for. What we're looking for is a just and equitable benefit sharing. Royalty scheme, in many instances, have not worked with many Indigenous communities because they're not given the proper capacity to be able to manage these kinds of royalties and use it for community development. Most often it's a dole-out system that's being done in the royalty scheme, and a lot of bribery and corruption are happening from up to down. So really, it's supporting Indigenous peoples to be able to lead their own self-determined development. And there are a lot of examples. And I know that there are private sector who has a bad record in terms of fossil fuel, but somehow they are sharing some of their CSR budget to be able to support these community-led initiatives, like Tonibong in Malaysia, who's really been working with off-grid communities for them to have mini hydro, to have access to energy, but at the same time also support their traditional livelihood through solar dryers that are fit for the community use, and also to support their natural resource management system. So it's more of a partnership where resources, technology support are provided to Indigenous communities and letting us implement on our own without any strings attached, like using us for promotion. And that's not what we want, no? We don't want to be used as a promotional material for these companies in saying that we are working with Indigenous peoples, we're giving them this kind of support. That's not the kind of partnership that we want.
That was Robbie Harlop ending that discussion with Prabin Shakya and my colleague at IHRB, Francis House. Francis, what are some of the most important things you took from that discussion?
Well, firstly, I'd say the critical importance of meaningful dialogue between what I'd call the duty bearers, the companies, and the rights holders, so the affected Indigenous communities, that there is proper respect for the FPIC processes. Companies need to be listening to and learning from local Indigenous knowledge, and that consultation needs to be ongoing. Another important takeaway from both Prabin and Robbie is there are very significant opportunities for shared prosperity in the growth of renewable energy. There need to be mechanisms included in government tenders, in companies and investors' due diligence. But it has to be, and I think both of them repeated this again and again, it has to be based on genuine, ongoing, meaningful consultation and dialogue with Indigenous communities. We need to move away from a one-off compensation model to a genuine partnership approach, not top-down development being done to communities, but communities having real agency in just and equitable benefit sharing. Robbie said that a couple of times. Just and equitable benefit sharing, I think, is really worth bearing in mind here. It's looking at that kind of benefit sharing to support Indigenous peoples being able to take responsibility for self-determined development. So while the opportunities, I think, here are huge, as they laid out clearly, the risks and challenges are significant. Examples of green conflict are already on the rise in a number of different countries. So their call to action, that urgent action needs to be taken by governments, by companies, to avoid simply repeating mistakes that the extractive sector has made over the past 30 years under the mantle of just transition.
Do you get a sense that things are improving when it comes to respect for Indigenous communities or not?
I think discussion around the topics is increasing. There are a number of multi-stakeholder initiatives emerging, which is encouraging. But in terms of actual concrete projects where you could point to shared prosperity being genuinely embedded in the project with proper consultation processes with Indigenous communities, I think you can still count them, on one or two hands. And I think those are mostly happening at community level, not yet at major energy development level. And that really is where a lot of the energy needs to be focused, I think.
Thank you, Frances. And thank you for listening to this episode of Voices, which is brought to you from the Institute for Human Rights in Business. Until next time, be sure to share and follow this podcast, that way you will never miss an episode. And if you would like to find out more about the work that we do at IHRB, then head to ihrb.org.